ground for workers' compensation immunity, which is Mr. Belial was actually in the course and scope of his employment with Dockside at the time of his injuries. The second is an election of remedies type defense that Mr. Belial elected his remedy, workers' compensation by settling with the employer and the workers' compensation carrier.
Well, he didn't really elect because the workers' comp carrier denied coverage based on its investigation and then left him with the remaining choice. I have a hard time buying into an election concept here.
Well, okay, Your Honor, we can talk about election. The point I was leading up to before your question, which I'm happy to address, is these are separate independent grounds. So if Mr. Belial was actually within the course and scope of his employment with Dockside, then the election of remedies doesn't need to be proven for him to have immunity. That was the point I'm making here, is that they're separate issues, both grounds for immunity. I would be inclined to agree with you that the clearer ground, and the one I was going to focus on for that reason, is the fact that Mr. Belial was in the course and scope of his employment when you apply the law.
Why isn't Mr. Roden stopped from asserting that ground?
Why is he not stopped?
Yes.
So we want to go to the estoppel portion of it. So I will address that, and it's a good question. And what I want to point out here, and it's important because when you look at their answer brief, they are asserting estoppel. They have the burden of proving estoppel, okay? Because they've argued a lot of cases where courts found no estoppel in support of their estoppel argument.
Why aren't you both asserting slightly different variations of an estoppel theory? You're sort of saying they're estopped to be estopped.
No, I'm saying, no, absolutely not, Your Honor. They have not established their estoppel avoidance, which is directed to our immunity defense. There is a separate estoppel affirmative defense that is distinct from the immunity defense, and that is estoppel against inconsistent positions based on the fact that they're trying to maintain two inconsistent positions.
That's sort of the estoppel against estoppel.
No, that stands alone. That does not relate to their estoppel.
Well, very important. I understand that they stand alone, but as a practical matter, their estoppel case is the one that the trial judge made the findings on that you want us to undo.
Your Honor, I think the trial judge made findings on all of them. Here's the point that I was trying to lead to all the bases. The clearest and most obvious path to workers' comp immunity here is, first, Mr. Belial was within the course and scope of his employment. And secondly, as Judge Lucas inquired about, they have not proven their estoppel avoidance directed to that affirmative defense, okay? So the estoppel against inconsistent positions within the lawsuit is not germane to those 2 points. They stand alone, okay? So if we're going to look at their estoppel avoidance, to answer your question, Judge Lucas, the elements are an inconsistent statement, or an initial statement that's inconsistent with a position later taken. In these cases, it's a denial of workers' comp claim. Okay, reliance, and then a change in position based on reliance by the plaintiff. The clearest, and let me, by the way, cite or read you the quote from Coastal Masonry, which is one of the cases they're relying upon. We fully accept all their case law. This case is distinguishable from those cases for reasons I'm going to explain. And in Coastal Masonry, it says, Florida law, however, makes it clear that judicial estoppel is a narrow exception to workers' compensation immunity and only available when the employer attempts to take inconsistent positions. When the employer attempts to take inconsistent positions. I'm going to come back to that. But they have to prove reliance. What happened here was there was a denial by the workers' compensation carrier on August 2nd, 2018. The very next day, they filed their lawsuit that we're hearing today, their original complaint. Soon after, almost contemporaneously, they continue to pursue benefits from Zenith and from Dockside under the workers' compensation policy. Okay, so they do that. They convene a mediation.
Well, Zenith had denied the benefits.
Correct.
They filed their lawsuit.
Correct.
And at that point, how are they continuing to pursue the benefits in a conventional sense with Zenith? I mean, they've got to deny it.
Because they went to Zenith and they convened a mediation with Zenith and they extracted $450,000 in benefits under the Zenith policy, none of which happened.
Which Zenith itself characterized as being not benefits.
Yeah, and Your Honor, that is an oxymoron we submit to you. You have to, there's no coverage in the policy that says no coverage benefits or denial benefits.
Zenith can make its own business decisions about, as your opponent put it, out of whether and how to buy its piece, because presumably there's another claim behind the denial if the plaintiff had wanted to pursue that further, and Zenith would have a business reason to try to buy out of that.
Sure, Your Honor. The question that you asked relates to the first aspect of the estoppel, which is a denial. Okay, and that the question you're raising is, was there still a denial after Zenith made the $450,000 payment, which were benefits under policy? We submit to you there wasn't, but I'd like to finish on Reliance first. They received Mr. Belisle received $450,000 in benefits. Okay, there are two bases for claiming Reliance. Are A, he paid medical expenses out of his own pocket. Well, the record establishes that those were $13,000 in medical expenses for which he was fully reimbursed by the $450,000.
We have a really skeletal record on this. I cannot imagine that this plaintiff's medical expenses were limited to $13,000.
What he paid himself, which is what they talk about in Byerly. What they did was they structured this under Byerly and Coastal, and they talk about the injured party relying by coming out of pocket to pay medical benefits himself or herself. The injured party in this case is Mr. Belisle, which is why they attached.
And he paid $13,000 out of pocket, right, which for him was probably a lot.
Okay, and he got $450,000 back, fully reimbursed for that. Okay, so that can't form the basis for Reliance. And then the other basis that they claim for Reliance is the filing of this tort suit. And again, they
got the $450,000 a year after the accident. The nature of these injuries are such that I would imagine they continue to require treatment for more than a year.
I'm sorry, I didn't understand your question.
I'll withdraw.
You sure? Right. Okay. There's no doubt that his treatment and his, the medical expenses are much more than $450,000. If that was the point of the question, we're not here questioning that. Okay. But the point is, back to estoppel, which is their avoidance, which is their burden to prove, they have to prove Reliance. They try to do it by saying Mr. Belisle himself, he signed the affidavit, they attached the medical records, incurred $13,000 in medical expenses, he was reimbursed. Secondly, they say we filed this lawsuit. Well, the cases that they rely upon are Coastal, Byerly, and Ocean Reef. In those cases, after the employer denied the workers' compensation benefits, either directly or through the insurer, the injured party did not go back to the workers' comp carrier or the employer and say, pay me benefits or pay me anything like that. They went straight to the tort action, and the employer was sued in the tort action. The employer was sued. So then the employer came in and said, oh, no, there's workers' compensation immunity. Here, Do All Dockside is the employer. Do All Dockside and its insurance carrier, through its insurance carrier, paid $450,000 in benefits under a policy that required Mr. Belisle to be within the course and scope of his employment, and then was released from the lawsuit. It's the opposite of what happened in Coastal, Byerly, and Ocean Reef, where there was only a tort action pursued against the employer. So they have no reliance. Even if you want to say there's a question about whether there was a denial because of the payment that was accepted and the release of Dockside, they have no reliance to support their estoppel avoidance, which means the law that establishes that Mr. Belisle was within the course and scope of his employment at the time of his injuries establishes immunity, and their avoidance fails. Therefore, he was entitled to immunity. The other estoppel argument is separate. The election remedies is separate. Those are separate issues. Now, on the denial, I would submit to you, we would submit to you, as we've argued in our brief, that you can't deny a claim and pay $450,000 in policy benefits under that same claim. Over and over and over again, what they've said is Ms. Vendetti testified that it was payment of a denied claim. That's their
Look, you represent insurers. They can do whatever they want to get a release. And
sure.
That's what happened here. And they expressly disavowed, and everybody agreed that signed off on it, that these weren't benefits.
That's not correct, Your Honor.
In what way am I wrong?
The way that you're wrong is there was a release signed off on by the plaintiffs, not signed off on by Mr. Roden, which said your standard language in a settlement, there's no admission of coverage. There is, no admission of coverage. This is a doubtful and disputed claim signed off on by the plaintiffs, not Mr. Roden. The release that was signed in the action. So Mr. Roden never signed off on that, okay? So that's one point. The other point is, look at the confession and judgment cases, which I understand arise in a different context, post-suit, 627, 428 attorney's fee claims, entitlement. But no matter what an insurer puts into that settlement agreement, if it pays after the lawsuit is filed, it can say 10 ways to Sunday. This is no benefits, this is no coverage, this is no nothing. They have confessed judgment. In
that doctrinal context, I don't disagree with you, but this is not a confession.
Well, my question would be, and what we said in the brief, is why should this situation be treated any differently? Why should the insurer be able to be found to say, or why would it be found that the insurer is still denying, even after it paid benefits, whereas if it had happened...
Because that's the deal we struck.
Well...
I mean, if you don't like it, look,
Mr. Roden didn't sign off on that deal.
Okay, and Mr. Roden is not necessarily without recourse if his insurer left him on a hook, right?
Okay. Well,
that's a separate issue. And I'm not gonna wedge you. Don't worry. But if that's his problem, then look, why didn't this fully release me? That's between him and his insurer for purposes of why we're here today, which is construe this release and construe what it amounted to. I have a hard time looking. I mean, I know you really want us to look behind it and say, well, but they got $450,000, but it's literally the record. What record we have is riddled with them expressly saying over and over again, this is a denied claim.
Your Honor, respectfully, that's a form over substance. I mean, they can say that they did not sign. They didn't sign a single case.
The reason they denied the claim is that their investigation, which your client drove, it turned up that he was trimming trees for this guy's birthday party. It didn't have anything to do with Do-All Doc Supply.
And the law is exceedingly.
And your guy agreed with that.
That's just not correct, Your Honor. First of all, Mr. Roden submitted the claim to workers' compensation, okay? On behalf of Do-All Dockside, on behalf of Mr. Belial, Do-All Dockside through Mr. Roden, Mr. Roden submitted it, okay? You read his deposition testimony, and the questions asked to him, wasn't he working for you personally? And please read what's in the brief. And he says, truth be told, he was being paid by Dockside and he wanted to please the boss for Dockside. But yes, the task that he was doing was personal to me. And then the question that they rely so heavy upon is their trial counsel saying, setting aside or recognizing that he's being paid by Dockside, he was still working for you, he was working for you personally. And Mr. Roden says, yes, you could slice it that way. Your Honor, under the Moody, the Alvarez case, 440.092, it is beyond clear.
In Moody, the facts were that the employee was working part of the day for the employer and then came to do something personal at the employer's home. Do we have those facts here when Mr. Belial was working for Mr. Roden for 2 solid days? Personally at his home? What
happened in Moody's at the end of a workday.
Correct. Do we have that here?
We have 2 consecutive work days.
2 consecutive days at his personal home for his personal party.
Where Mr. Roden told him at work, for work tomorrow, come to my house. You're working for Do-All Dockside, I'm going to work at my house. At the house that day, the first day, he told him come the second day. And we're going to work at the house and you're working for Do-All Dockside.
And I'm not sure what our record is on this, but did Mr. Belial, as part of his standard workday when he was working in conventional Do-All business, was he trimming trees in a bucket loader or was he working on boat repairs?
I'm not aware of him ever trimming.
Because it seems like it's a little bit different than, since trimming trees is probably not the primary business of Do-All.
It certainly is not. Do boat repair is. And again, the case law makes it very clear that when you do something in the personal, for the personal benefit of your supervisor, the personal benefit has nothing to do with the business. Alvarez and Moody say it very clearly. Moody says the farmhouse lock that was being changed, the farmhouse had nothing to do with the restaurant. In Alvarez, it was a computer table for the manager's wife at their house, and they say the trial judge found it had nothing to do with the business, therefore it was outside the scope, and the appellate court reversed that finding.
And in both those cases, wasn't the injured party proactively seeking the workers' comp coverage? What the equivalent of was, and the employer was denying it?
That's correct. They were seeking workers' compensation benefits. I assume you're tying into the argument that they made that that's a distinguishing factor, which it is not, because you cannot have workers' comp benefits without workers' compensation immunity. Under 440.11, if there's workers' compensation coverage, it's a covered act, they get benefits and the immunity applies. So you can't separate the two.
Just to let you know, you're in your 5 minutes now.
Thank you. I'll reserve the rest.
Okay.
May it please the court, I'm Julie Ricky Rubin, along with Ty Rowland, who's trial counsel, and I have with me Logan Belisle and his parents, Brian and Christina. Judge LeBritton, I'm not sure if I pronounced that correctly. I think you hit the nail on the head with the very first question that you asked opposing counsel. The day that this carrier denied coverage was the day that this ceased being about a course and scope of employment analysis mode, and it went into what Judge Lucas pointed out, an estoppel analysis mode. And we know from the Byerly decision that when a carrier who rises and falls with the employer, when the carrier makes a decision to deny coverage because the person is outside of the course and scope of his or her immunity, that then entitles the victim to do one of two things: to challenge the decision denying workers' compensation benefits, or to pursue a claim of a civil claim. And that's what occurred here. They made the denial. The discussion about whether Logan was in the course and scope of his employment at this point is really no longer material, and that is something that Judge Gentile found. So the question becomes, this estoppel, and understandably, we have the burden of proving the avoidance estoppel, that there was a representation of fact, the denial, and that this representation is now being represented differently in this proceeding or in the proceeding below. No, he's in the course and scope. And that Logan relied on that denial and did so to his detriment. So as soon as they got the denial from the work comp carrier, what else is there to do? There's no course and scope. He didn't even believe he was in the course and scope of his employment because, again, Judge LeBritton, as you pointed out, he was trimming trees in a bucket truck instead of doing boat fiberglass work, was what he normally did. But when he decided to pursue the civil claim, all he had to incur medical expenses, whether the health insurance paid it, somebody paid it, and he paid it. And he went from that point and had to then bring a negligence claim. And a negligence claim is a lot more involved than a workers' compensation claim. There's no fault in work comp, and you have to prove fault in a negligence claim. So the detrimental reliance and the estoppel was all there as a matter of law, and that's what Gentile found, and that's why he granted summary judgment. Now, these other defenses, the election, the estoppel, inconsistent positions, judicial estoppel, they all rise and fall on this untenable argument that $450,000 of a settlement that an insurance carrier, for whatever reasons we don't know or not on the record, has decided to pay, that magically transformed into workers' compensation benefits. But as all of you have pointed out, everything in the record contravenes that was the case. And I will read to you some of Ms. Vendetti's testimony. She was asked, would you agree this $400,000 was paid to Logan Belisle pursuant to coverage under a Zenith policy for workers' compensation issued to Dual Dockside? And the defense counsel says, was that a yes, ma'am? No. I said it was paid to resolve a claim that was denied. So there was no admission of coverage. Another question, we agree the coverage was open under Section 1, which is indemnity and medical.
I mean, it's fair, right, to describe this at worst as sort of a gratuitous payment. Is that an unfair descriptor?
I don't believe it's gratuitous, Your Honor, because the insurance company did have a reason for paying these benefits.
In what way? Or not benefits, right?
I'm sorry, to pay a settlement, to buy.
What was their incentive?
Well, one of the incentives, they did, if you go to page 942 of the record, and we look at the actual policy, and that's the different sections of the policy, and that's the exclusion section of the policy. So Dockside, or Zenith makes this decision that they're not going to pay these benefits. And it's clear from the exclusions in the policy, number 2 and number 3, that the policy doesn't cover punitive or exemplary damages because of bodily injury. And paragraph 3 says that bodily injury to an employee while employed in violation of law, and we have argued and asserted a violation of child labor laws, those two things would not have been covered. So once the defendant, the carrier, denied this claim, it left the employer exposed. And the employer in this case could have easily been exposed to these kinds of damages. So buying its piece and buying its insurance piece to perhaps not have, well, I guess Dockside doesn't have any recourse, but Judge Lucas asked about whether Mr. Roden may against Zenith. But this way, it was protecting its insured. We have in the record also that there was a permanent and total disability report that was run subsequent to the denial and before the settlement was reached. It was 56 pages long. It took permanent and total disability benefits out until, for 75 years, I believe, of Logan's work life expectancy. I think it was out to like 2076. It's on pages 980 to 1035. And that reflects that the payments that Zenith would have paid if Logan had been deemed permanently totally disabled would have been hundreds of thousands of dollars. And the adjuster was asked, did you do this for medical expenses? No, we didn't run that report. But they knew they were sitting on a very significant claim. So once they made this denial, he's out of the course and scope, and they continued to stick by it. You know, defense counsel's position might ring true if there was anything in this record which showed that Zenith believed he was in the course and scope or changed its mind. But the mere decision, because they declined to defend, they had always defended, and that's from the Waller case. They continue to defend to this day that he wasn't in the course and scope of employment. So the reason why Judge Gentile found that this $450,000 settlement did not constitute workers' compensation benefits is because there was not one iota of evidence to support that it was. Unless the court has any other questions for me, I would ask that the court affirm this decision below. Thank you.
Thank you.
Yeah, I know how much time I have.
Yeah, 4 minutes.
4 minutes, thank you. May it please the court. Your Honor, counsel said that Mr. Blau was left with 1 or 2 options. Workers' comp, or petition the denial of workers' comp or file a tort suit. There was a third path, which is what was followed, which is file a tort suit and then go back to the insurer and try and secure Zenith, the workers' comp and employer's liability insurer, and try and secure some benefits under that policy. What if Zenith had paid?
Well, he sued Zenith's insured in the tort suit.
Correct. Right. And I want to come back to that because that's the estoppel against inconsistent positions that stands alone as a separate affirmative defense. What if Zenith had paid $15 million under this policy, or just in the settlement, and then signed and said, we deny all liability? Does that get them off the hook? There's no payment, there's no election. What if it was $1 million? What if it was $7 million? Where do you draw a line if you're going to look at the number like that?
What difference does it make if the insurer is acting on the basis of its investigation with the insured and the facts that I don't think anybody disputes? This guy's trimming trees in the company owner's backyard. He's not fixing fiberglass on the boat dock. Nobody
disputes those facts, but under the law, he was within the course and scope. I don't want to retread all that ground again. But Zenith was wrong, and with their denial, and they paid $450,000 under the policy. Now, what counsel also said was it didn't magically transform them into workers' compensation benefits. Well, then if they weren't magically transformed into workers' compensation benefits, then they were employer liability benefits. Now, you asked the direct question, Judge. Isn't this a gratuitous payment? Isn't that what you're saying? Let me read you Ms. Vendetti's testimony on that. right out in her deposition. Question, I understand that, but the $450,000 was paid pursuant to the policy. Yes, it was. And it wasn't a gratuitous payment, was it? Correct. So the same representative who their entire estoppel was based on, avoidance, has said it's not a gratuitous payment. It was under the policy, pursuant to the policy. Again.
Well, so she can say it wasn't a gratuitous payment, we'll buy into that, and she says it's not benefits, we have to reject that.
Exactly. Yeah, it was benefits under the policy. What else could it be? If it's not gratuitous, it's a payment under the policy, when the only thing you can pay under the policy is benefits. Okay? So let's look at the separate estoppel argument. They filed a complaint specifically designed to trigger coverage under the employer's liability coverage, because they said they sued Dual Dockside and they said Mr. Roden was in the course and scope of his employment directing Mr. Belial that day. That's to bring it under the employer's liability coverage. There is then a mediation, because it has to be. Mr. Belial would have to be within the course and scope, and Mr. Roden would have to be within the course and scope. So then there's a mediation, and there's a $450,000 payment paid after the suit is filed. After the suit is filed. How is that not a confession of judgment? And in this case, because suit was filed based on those allegations and those necessary facts. Okay, they file the $450,000 is paid. They file an amended complaint removing all allegations that Mr. Roden or Mr. Belial was working on behalf of Dual Dockside that day, and saying he was outside. Mr. Roden was working individually, not on behalf of Dual Dockside. And now they want to go forward on that against Mr. Roden. So they do it. They make an allegation to trigger coverage on the employer's liability policy. They get $450,000 in benefits, okay, which if they're not workers' comp benefits, then they're employer's liability benefits under that allegation, and now they want to proceed forward on a different set of facts. Totally irreconcilable. Mr. Roden was in the course and scope of his employment, give us $450,000, now he's not in the course and scope of his employment. That was a case that was in suit, and we can talk about $450,000 perhaps being small in the course of Mr. Belial's injuries, nobody disputes that. The employer's liability coverage under that policy was $500,000. So it was almost a policy limit payment under that particular coverage.
And with that, Mr. Hazuri, you're out of time. You need to wrap up.
Okay, I would just say two ways to get there. Either we prove course and scope, the facts prove course and scope, their estoppel avoidance fails, or the separate estoppel against inconsistent positions within the same lawsuit, which is the last one I just addressed. Based on those, we ask that you reverse the summary judgment and for the plaintiff and grant summary judgment for Mr. Roden on one of those two crimes. Thank you.
Thank you all. Last case, court.